Hi, everyone. Welcome to this evening's Insights from the Quad seminar. I'm Monica Hakimi. I'm on the faculty and one of the associate deans here at the law school. And we started this series during the pandemic because we know that a lot of people are more isolated than they otherwise would be and are looking for opportunities both to connect with other members of the Michigan law community and to learn from our amazing faculty. Before we begin today's session on voting rights in American democracy, let me just mention three logistical notes. The first is that this webinar is being recorded, and as a registered participant, you'll receive a link to a video recording after the fact. The second is that, of course, during this webinar, you won't be able to see other attendees. You'll only be able to see the three panelists. And the third is that the next session on criminal justice reform will be on November 10th at the same time with Professors J.J. Prescott, Eve Primus, and Margot Schlinger. So with that, let me introduce our two panelists for this evening, who I'm delighted to have with me here today. The first is Ellen Katz, who is the Ralph W. Agler Professor of Law. She writes and teaches about election law, civil rights and remedies, and equal protection. Second, Sam Bagenstos, who is the Frank G. Millard Professor of Law. He specializes in constitutional and civil rights litigation, and between 2009 and 2011, he served as the #2 official in the Civil Rights Division of the U.S. Department of Justice. We thought that today we would, of course, talk about the election-related disputes, many of which have already given rise to or can be expected to give rise to litigation, with the election just 3 weeks away. But because the topic is so massive, we thought we would focus on three, and if we have time, four geographic regions. So Wisconsin, Florida, Pennsylvania, and if we have time, Arizona. And let's start with Wisconsin, where voting rights issues relating to the pandemic first gained national attention. Ellen, maybe I could start with you and ask you to just give us a little bit of the background of what's been happening in Wisconsin, specifically relating to absentee ballot processing.
Sure. So thanks for organizing this, and I guess thanks to Jenny and Lara, Laura, and Brian for all their help putting this together. As you mentioned, there's a lot of litigation going on. By one count, 350 cases pending related to issues of election administration and pandemic-related questions in 2020. Sam and I thought a way to focus this is, as you pointed out, through some geographic specific cases. And so Wisconsin makes sense as a place to start because it's, I think, one of the first places where we saw the complications that the pandemic was presenting for election administration. And this was back in the spring, the April 7th primary that was taking place. It was a presidential primary, but also there was a lot of state offices on the bench. An important state Supreme Court race was going on. And weeks before the election, COVID cases started climbing nationwide, and the governor issued a public health emergency, a stay-at-home order, and Wisconsin voters started applying for absentee ballots in unprecedented numbers. And by the time the primary rolled around, the numbers was about 1.3 million requests. Previous elections had 200,000 was at the upper limit. So this was a huge number, and state election officials, local election officials were inundated with these requests and really didn't have the ability to process them. They literally ran out of envelopes. And at the same time this was going on, election officials in Wisconsin had a real hard time getting folks to man the polls, and they were short 30,000 poll workers. And this caused a closing of lots of polling places. And just to give a sense of the scale there, in Milwaukee, 175 polling places were closed, leaving the city with just 5 for in-person voting on the day of the election. And unsurprisingly, this gave rise to litigation. A bunch of cases were consolidated before a federal judge. District Court on April 2nd issued an order granting a preliminary injunction modifying some of the rules pertaining to the processing of absentee ballots. And specifically what the district judge found, refused to postpone the election, which was one of the things the plaintiffs had asked for, and instead recognized that the rules were giving rise to what he characterized as an unconstitutional burden on Wisconsin voters who had applied for an absentee ballot, had not received that absentee ballot, and were now confronting the prospect of either not voting or braving the polls and risking their health and the health of family members who might be particularly vulnerable. This was early on in the pandemic, obviously, and people did not understand lots of issues about the risks that they were facing, and there were these nationwide shutdown orders at the time. What the district court ordered was that Wisconsin should receive absentee ballots for a week after the election, and to allow voters who had not yet received their absentee ballots to be able to mail them in. And there were some other orders as well, but this was sort of the crux of it. While this was going on, the governor was trying to postpone the election, called the state legislature into session. The state legislature convened and went out of session within minutes, taking no action. The governor tried to postpone the election unilaterally. The state Supreme Court stopped him from doing that as well. The day before the primary, the Supreme Court issued its ruling. A per curiam ruling was a 5-4 decision with 4 justices dissenting, scrapping the district court's order, and basically saying that Wisconsin need not accept absentee ballots after the date of the primary. And I just want to say a couple things about this. I'll try to be brief, just to get the conversation going. So the order was the Supreme Court's opinion was clearly written under time pressures, and it did 2 things that I think we see affecting or evident in a lot of litigation that has followed. So the first thing that the per curiam said, or of note, it invoked what you may have heard about in lots of news of late, the so-called Purcell principle. Federal courts ought not to intervene in elections too close to the election. Ordinarily, they ought not to intervene. The risk of confusion to voters, the risk of disenfranchisement is such that federal courts should act with caution. And this comes from a kind of odd case 14 years ago in which this this notion was articulated. Justice Ginsburg's dissent said there's nothing ordinary about what's going on in Wisconsin at the moment. This is not an appropriate place to bring up the Purcell principle. Lots of critics echoed that sentiment, and in the months since, we've actually seen a lot of criticism of the very idea of the Purcell principle. Is it a principle? What is it? Is it just a presumption? Is it just an act with caution? Or is it a hard and fast rule that federal courts ought to never intervene? And to my mind, unfortunately, we have recently seen the latter being the dominant understanding of it. The other thing I just want to say quickly, and I'm already talking longer. I know we're having a conversation and I'm going on a little too long here, but let me just say what I would call the merits ruling, apart from the Purcell part of the holding, the court scraps the district court's order or remedy that was based on an understanding that Wisconsin procedures as is, if unchanged, gave rise to an undue burden, an unconstitutional burden on voters who had followed the rules, asked for an absentee ballot, which Wisconsin law grants them on demand, had not received it, and now faced this untenable choice. And Justice Ginsburg's dissent described the court's ruling as giving rise to massive disenfranchisement, tens of thousands of people being unable to vote or being forced to vote under circumstances that the district court understood, that the dissenters understood to be unconstitutional. And what I think is one of the things so interesting about what the majority does is it calls Justice Ginsburg's argument quite wrong, that her rhetoric is misplaced, and that this is a limited and technical decision. We're not ruling on the wisdom of holding an election under these circumstances. Wisconsin can cancel the election. It's up to Wisconsin to decide whether this is a good idea or not. It can't be stressed enough, says the per curiam, that that's not what it's up to. But implicit or maybe explicit in that holding is the notion that Wisconsin, wise or not, can constitutionally hold an election under these circumstances. And maybe I'll stop here because there's much more to be said, but I think in that holding, in that suggestion, is a really narrow conception of what the right to vote is. And it's a conception that didn't come out of nowhere. I think we had a dozen years at least, arguably more, of precedent in which the court has steadfastly circumscribed what that constitutional right to vote is, what its contours are, what the degree of state discretion is in crafting them. The court, and let me stop there because I know there's a lot to be said, but just to sort of frame it, lots of the other cases that followed, Alabama, South Carolina, Texas, Wisconsin again just last week, we see that same invocation of the Purcell principle and a very narrow understanding of the vote.
Wow, that's great, Ellen. Thank you. Or it's a great overview. It's not a great, the facts are not great, but there's so much that you said there that I want to follow up on. And so, Sam, maybe we could start with this question. If you could talk, or to these two questions, if you could talk a little bit about some of the implications of the Purcell principle notion, whatever we want to call it, hardening into something like a rule. And second, if you could talk a little bit about given that the constitutional right to a vote has narrowed over time, what its content actually seems to be at this particular moment in time.
Yeah, so those are great questions, and thanks for having this, and thanks to the over 100 people who are watching, which is very impressive to me. There are many things like this, many Zooms people can be on right now, and they're on this one. So hopefully we're entertaining you well and informing you well. So the Purcell principle, I mean the content of it, or the implications of this Purcell principle, I think it's really worrisome. And I think it's really worrisome because, look, the basic notion of don't change things too close to an election because voters will get confused. That makes sense as a consideration to have out there, as a consideration that election officials should have, as a consideration that judges should have in issuing relief. And, sort of as Ellen was suggesting, the original conception, I think, of the Purcell principle, honestly, the principle is something that scholars created. And, really it's something that people are deriving from stray remarks in various rulings that, like this Wisconsin ruling, were issued really quickly. But the basic idea behind the principle sort of makes sense, right? You don't want to change things too close to an election because even if the change is a good one, the fact that you're changing is going to deter so many people from voting or confuse so many people that the net effect on voting is going to be negative, or at least could be, right? It's something to think about. But when that hardens into this principle that you just don't let the federal courts make changes too close to an election, then what you do is you disarm the federal courts from being able to deal with problems that arise right on the heels of the election, and circumstances that are maybe incredibly disenfranchising, may have a disenfranchising effect that's way greater than any confusion that might be caused by an order close to the election, right? We may end up saying, yeah, we're just not going to deal with that. And I think that's the concern. That's the concern with the Wisconsin case and some of the other cases that we've been seeing that are invoking this Purcell principle as a way of effectively stopping courts from remedying serious disenfranchisement. And let me talk about the disenfranchisement too, and which gets to your second question, which is, as we've seen this narrowing of the right to vote, as it's been understood by the courts, one of the things that I think is notable, a lot of this comes out of litigation surrounding various procedural barriers that have been put in the way of voting, purportedly in response to concerns about voter fraud. So voter ID laws, for example, are the paradigm case of this. And you can make a lot of arguments about voter ID laws and whether they're unconstitutional or not, and why they should be unconstitutional. But I think one argument that the folks defending the voter ID laws, and that the courts, and particularly the Supreme Court, which by and large has taken a narrow view of the voting right here, has been able to say is, look, what you're saying is these barriers shouldn't be put in place, but it's still perfectly possible for you to vote if you just follow the rules. And yeah, maybe it's burdensome to get an ID. We don't think it's as burdensome as you think, but either way, you can get an ID. If you follow the rules, you can vote. The problem with the Wisconsin case is we have a lot of people who are following the rules, who submitted their ballots in a timely way under state law, and through no fault of their own, because the mail system's overwhelmed, because the clerks are overwhelmed, because the system is overwhelmed by COVID and by this rise of mail voting, their votes end up not getting counted. And so that is something that, to me, breaks significant ground in terms of narrowing the right to vote even further.
Mm-hmm. Ellen, do you want to weigh back in? And I actually have a follow-up question that I might pose too, which is, could you talk a little bit about how the closure of so many polling places intersected with the resultant disenfranchisement of voters. So we talked a little bit about how, the voters who requested absentee ballots are basically not going to be able to vote. But what about the closure of the polling places, which we've seen in other parts of the country as well?
Yeah, I mean, technically it wasn't part of the order, and I think it captures this idea that the right to vote is not unconstitutionally burdened so long as voters have the legal on the paper ability to vote. So even the voters who had asked for absentee ballots and didn't get them were still able to vote in a legal sense. They could show up in Milwaukee in one of the 5 places that were open. Long lines, there were safety concerns, needless to say, about it. And so, what to say about it? I mean, I think in part, it informed what the court was worried about. I think beyond the specific issue that it was presented with, but this idea, well, how many polling places need to be open in Milwaukee to comply with a constitutional standard? And I think the court just punted and said, however many Wisconsin wants. 5 is a really small number. How long is too long to wait in line? There were people yesterday in Georgia waiting 12 hours to vote. That is voter suppression to my mind. And it is an unconstitutional burden to my mind, but I'm not the one making these decisions. And I think the court, in thinking about the absentee ballot issue, was cognizant of the fact, well, look, Wisconsin allows these ballots on demand, but it need not have done that. And in sort of baked into the plaintiff's claim and the lower court's finding was this sense that voting in person in the middle of the pandemic is an unconstitutional burden on the right to vote. And that suggests, yeah, you need absentee ballots on demand. And that might mean you can't have witness requirements for filing of absentee ballots, and maybe signature match requirements need to be loosened. And maybe you actually need 180 polling places for people who show up in person. And maybe the line can only be 10 minutes long, and maybe you need this, and so on and so forth. So, and I think the court's like, we can't decide any of that, or we won't decide any of that. We're going to leave all of that to Wisconsin, to the states to decide what the best way to vote in a pandemic, just like the best way to vote under other circumstances, so long as the plaintiffs here are not alleging a complete inability to vote. Echoing back something Justice Stevens said back in Crawford a dozen years ago when they first upheld the voter ID measure against a constitutional challenge. So long as no one's alleging a personal inability to vote, we're going to basically say no harm, no foul. And I think that's what we're seeing. And again, in the months since, there have been some lower court rulings providing some relief, either the appellate court stepping in or the Supreme Court stepping in, or the district courts denying relief in the first instance to say, no, this is up to the states. This is where you have to have this argument.
Okay, so let's shift regions. Let's move from Wisconsin to Pennsylvania. And I understand, Sam, that a number of the issues in Pennsylvania are similar to the ones in Wisconsin, although correct me if I'm wrong, but they have some added wrinkles. So could you give us a little bit of a description of what's been happening in Pennsylvania?
Yeah, absolutely. I think Pennsylvania is probably competing with Wisconsin for being, the absolute epicenter of legal fights around the election, at least pre-election, and not surprisingly, given, its likely pivotal role in the presidential race, and the fact that, like Wisconsin, it has a Democratic governor and a Republican legislature. So, there's a great potential for conflict. And I think Wisconsin's going to be a place where we're going to, Pennsylvania is going to be a place where we're really going to see a test of the last thing that Ellen just said, which is this really something that the federal courts believe is for the states to decide? So, and we have, this very question in the Supreme Court right now. So, the basic background to Pennsylvania is exactly the same as the background to Wisconsin, right? Divided state, very close in the 2016 presidential election, likely to be very close in the 2020 presidential election. COVID is happening, meaning an increase in the use of absentee voting, mail-in voting, and all the rest. And what that's led to in Pennsylvania is a lot of litigation over a series of interconnected issues. And the litigation is actually sort of bounced between state court and federal court. The Trump campaign as the Trump campaign. Often campaigns kind of use a cutout for this, but they actually sued as the Trump campaign, I think trying to make a point that they wanted to do this. Sued in federal court. Actually, they were in front of a Trump-appointed federal judge, sued in federal court saying the state needs to do a bunch of things to avoid voter fraud in this election, among others, get rid of drop boxes for absentee ballots, make it much easier for parties to have poll watchers. The state limits poll watchers to the county where they live. And what the Trump campaign said is, no. We've got to be able to get poll watchers from anywhere in the state to go to anywhere in the state. That's got to be required. You've got to do various things about checking up on the signatures of absentee ballots, they said. Also, crucially, they said that you need to prevent third parties from collecting absentee ballots, because there's a narrative among many folks, particularly on the right, that when third parties collect absentee ballots and turn them in, that creates a vector for voter fraud. And, that is something that's happened sometimes. It's also been a way that community organizations have empowered people to actually vote. And so it's a complicated policy issue. And what the state, the state executive branch controlled by Democrats did, is said this should really be considered in state court. And so there was a separate state court lawsuit that was considering those issues, plus the question whether, in light of the massive increase in mail-in voting right now and the degree to which the Postal Service seems to be overwhelmed, and the many, well-documented problems with the Postal Service over the summer when this litigation was getting started, the litigation said the state needs to, as a matter of state constitutional law, interpret its laws to count any vote that is either postmarked by Election Day and received by 3 days after Election Day, or that's received by 3 days after Election Day and there's no postmark on it whatsoever. And the argument here was essentially, look, these are voters who did everything right, and it's not on them that the Postal Service didn't deliver in time or that the Postal Service didn't put the right stamp on it. So these are people who voted on time. And given that they voted on time, their vote should be counted even if they arrived later. State statute said, no, the vote actually has to be received by Election Day. And what the plaintiff said is this is inconsistent with the state constitution, which contains a voting rights provision and has contained a voting rights provision since actually before the U.S. Constitution. It's something that goes back to the earliest constitution of the Commonwealth of Pennsylvania. So the Democrats ultimately win that battle in state court. So they win in state court an order saying anything postmarked by Election Day or that contains no postmark, if it's received after Election Day, gets counted. That issue gets taken to the U.S. Supreme Court by the Republican Party, by a series of Republican legislators. And what they say is, actually, this isn't a matter for the state, because this is changing the date on which the election occurs, and that's a matter that Congress has determined. Or alternatively, this isn't a matter for the state courts to hold unconstitutional a state statute under the state constitution, because the U.S. Constitution vests in the state legislature the power to decide what are the times, place, and manners of holding federal elections. And those of you who remember Bush versus Gore back in 2000, remember there was a version of this argument that was floated in the litigation that three justices in the Supreme Court, slightly different argument, but a close cousin, and many people think this is a stalking horse for that argument, that was floated in that litigation. Three justices endorsed, but was not endorsed by the majority. The Republican defendants and defendant interveners have effectively asked the U.S. Supreme Court to say, as a matter of constitutional law, that the state Supreme Court has no power to hold unconstitutional a statute adopted by the state legislature under the state constitution. The argument is legislative power means the legislature can do what it wants. What the argument on the other side is, no, legislature in the US Constitution means the legislature under whatever power it has under state law. So obviously under the lawmaking process under state law, it doesn't mean cutting out the governor. It doesn't mean cutting out any constitutional restraints under state law. There's a lot of authority for that argument in Supreme Court precedent, but there's also a lot of reason to believe that many of the more conservative justices are going to be open to the argument that legislature just means legislature alone. And this, and I'll stop in 1 second, this has implications for potential shenanigans that happen post-election. If, for example, the popular vote in a state with a Republican legislature and a Democratic governor, like, say, Pennsylvania or Wisconsin, or, by the way, Michigan, if the popular vote went for Joe Biden, but the legislature wanted to certify a slate of electors for Donald Trump, what they would point to is similar language in Article 2 of the Constitution that says the legislature directs how the electors are selected. And there's been this argument ever since Bush v. Gore unresolved about whether that allows the legislature to cut out the governor. I'm really hoping we don't confront this, but many people think this Pennsylvania case is kind of a stalking horse, or at least an indicator, a leading indicator of where that fight might come should we be in that situation post-election day.
Mm-hmm, mm-hmm. Okay, Ellen, I want to turn to you to weigh in on the Pennsylvania situation, but I guess I have a question, which is it right to say, I might not have followed exactly, that a cert petition in this case has been filed, but has not yet been, the Supreme Court has not yet decided whether to grant cert, and so that is still pending. Is that right?
Yeah, and we've been waiting. I think that many people thought this would have come down by now. So.
Okay, and so could you talk a little bit about what you think some of the implications of this case are for Pennsylvania and other states, like Sam said, like Michigan, that are similarly situated?
Sure. I mean, it's an interesting question. I mean, it does bring you back 20 years ago to Bush versus Gore, and I do recall thinking in the weeks following the election, with various things happening in Florida, will the Supreme Court take this? It was a discussion, and asserting to various people with a good deal of confidence, these are state law issues. The Supreme Court can't get involved in here. There's no federal question. That was not correct. And, you know, looking back, the Chief Justice Rehnquist wrote this concurring opinion that Sam mentioned. There's something to the idea that there is a legislative power and that the Supreme Court can't, there's the word legislature in the Constitution, and the state Supreme Court can't just do whatever it wants and reject anything. But I think, as Sam pointed out, the notion that this doctrine, the independent legislature doctrine, somehow frees the legislature from the normal constraints of state constitutional law, judicial review, and the like, is, can I say, loopy? I'm not even sure that Chief Justice Rehnquist was pressing that, and he was more saying that this fell outside of permissible bounds of judicial review. I think Sam hit all the issues about what could follow, just to make that parade of horribles seem a little bit even more horrible. Should a majority of the present court be receptive to this claim, the implications are not just to what might happen in the popular vote legislature new slate kind of scenario, but it has implications for a host of election law issues. Not long ago, there was an argument of this sort challenging Arizona's Independent Redistricting Commission, and that redistricting by commission was usurping the power of the legislature to make decisions. We have a redistricting commission created by constitutional amendment here in Michigan now. That same argument could be made, the same challenge could be made, that these commissions usurp legislative power. That Arizona case was a 5-4 decision in which Justice Kennedy was the deciding vote. There's not a majority for that position one might be skeptical that there's still a majority for that holding. And so the implications of the Pennsylvania case could reverberate well beyond the presidential election to sort of some of the most promising mechanisms to my mind, again, to restore, bring more democratic, more representational policies and fix some of the problems we've seen in election law over the last 2 decades. So the implications, I think, are, and let me say, it extends the redistricting commissions. It also could arguably extend to electoral reform done through constitutional amendment, like we did again in Michigan, with the Promote the Vote, deciding, new procedures for how state and federal elections occur. Is that usurping the power of the legislature to set these provisions? So the ramifications are huge.
Okay, Sam, did you want to say anything more about Pennsylvania? Are we ready to move on to Florida?
Why don't we move on to Florida?
Okay, great. And here, Ellen, we'll come back to you to start. So Florida has gotten a lot of attention because there's been a lot of talk about restoring the voting rights to people with criminal records. And also a lot of talk about Mike Bloomberg getting involved in facilitating that restoration of voting rights. And so the starting question is, again, could you tell us a little bit about what's been happening in Florida, Ellen, on both of these, both with respect to the restoration of voting rights and then also Mike Bloomberg's specific role and exactly what he's doing or trying to do?
Sure. And this, again, is, this is not a cheery story. And it started as one that actually was. So 2 years ago, November election, Florida voters, by 65% of them, voted to amend the state constitution to let citizens with felony records vote, and that any disqualification that stemmed from having a felony conviction terminated. So the constitutional amendment, and voting rights shall be restored upon the completion of all terms of the sentence, including parole and probation. And this amendment by the voters was thought at the time that 1.4 million people would become eligible to vote as a consequence of it in the state of Florida. In June of 2019, the Florida legislature passed SB 7066 with the governor's support, and held or provided that completion of the sentence included paying off all legal financial obligations. And this was a several $100 obligation for everyone, and for many people much more than that, thousands, in some cases millions of dollars that would be owed before someone could have their voting rights restored. Lawsuit follows alleging that this payment obligation violated the First Amendment, the Eighth Amendment, 14th Amendment, was a poll tax, and the process through the federal court that followed is torturous. District Court in the fall of 2019 issues a preliminary injunction saying that that this provision violates the Equal Protection Clause and enjoins the Secretary of State from enforcing it against the named plaintiffs. Goes up in the winter of 2020 to a panel of the 11th Circuit that affirms the preliminary injunction. A panel affirms it, and in fact goes on to say, this is not a heightened review situation. Florida's requirement is irrational. Under the lowest level of review, it inflicts a continuing form of punishment on indigent people with felony convictions. Or at least suggested that it didn't pass rational basis. Goes back to the district court in the spring, class is certified, full trials held, and the district court issues a permanent injunction against the enforcement of the LFO's illegal financial obligations, calling it irrational, calling it a wealth-based barrier to the restoration of voting rights without sufficient justification, also a poll tax under the 24th Amendment in violation of it. And also, by the way, Florida doesn't even know how much money anybody owes and doesn't seem to be able to tell anybody about it. It will take Florida at least a decade to figure that out, and that's a problem. Kind of seems like it is a problem. And what's amazing, and I think so disheartening, troubling, shocking, I don't know, pick your word, what happens after that? District court issues this permanent injunction. The 11th Circuit goes immediately en banc, doesn't hear it in a panel, goes immediately en banc, stays the district court's order. Supreme Court won't lift the stay. it prompts a dissent from Justice Sotomayor with Justice Ginsburg and Justice Kagan pointing out that 1 million people are going to be barred from voting as a consequence, invoking the Purcell principle. Like, what are you talking about? This is not the kind of thing for the Purcell principle. The 11th Circuit rules last month. No equal protection violation here, no problem with this. The Constitution allows states to disenfranchise people with felony convictions, invoking a Supreme Court decision from the 1970s that hasn't moved. I don't expect it to move. And because states can disenfranchise people with criminal records, the terms upon which they are brought back into the electorate lie with the state. And we're going to review that decision or the rules that the state's putting in place under very low-level review. It's not unfettered. The state couldn't say only women could come back or only white people could come back. At least they couldn't say those things explicitly. But there's very deferential review here, and the court basically concludes that there's no violation here of the Constitution. And hence, this restoration of voting rights to 1 million plus people is basically halted because of the practicalities of it. Tampa Bay Times reported yesterday about sort of what the status of this is, and they come up with 31,000 people who have registered as a consequence of the amendment, not the 1 million plus that were expected, or several 100,000 at least. And of the people who have registered, most have reported they will not vote in November because of fear. They registered during this period of time when the injunction was in place, and a fear that they owe money and that they could be prosecuted for voting without permission. Without legal right to do so, I should say. Last word just about Mike Bloomberg. It's been reported widely. Raise money to pay the fees for 32,000 people in Florida, all of whom owed $1,500 or less. It hasn't been confirmed. I mean, I was kind of optimistic about that. Like, that's, a way to go here, because the federal courts have been so unreceptive, or at least appellate federal courts have been so unreceptive to claims of this sort. It's not clear how many of those people have actually registered to vote, and there's reason to think that very few of them have, in sort of the original, some passing. So it's not clear, really, how much that constitutional amendment, which 2 years ago seemed like not just, again, to my mind, a step in the right direction, a step to fixing some of the sort of really difficult rules that we've been getting from the Supreme Court and lower federal courts, a way to sort of push back against it. And I'll stop there.
Okay, and Sam, I'd like to hear your thoughts on Florida. I do have this question. It sounds to me, as someone who is not steeped in this area of law, that a theme that we keep hearing is, well, where does decision-making authority proper lie? To what extent does it lie with the state versus the federal courts, basically? And it also seems to me that the decision on where decision-making authority properly lies consistently is made in the direction of, and this is a theme you mentioned earlier, narrowing the right to vote. So to what extent is that mapping accurate? And to what extent do you think the sort of narrowing of the right to vote is actually what's driving the decision, the desire to not interpret broadly the constitutional right to vote is driving the decision on where authority properly resides? Because that's sort of how it sounds as I hear you two talk through these cases.
I mean, I think it's very clear that there's a trend on the federal courts, and it's obviously been accelerated with recent appointments to the federal courts, toward reading very narrowly the right to vote in the Constitution. It is notable there is no explicit affirmative right to vote listed in the Constitution. Now, there are various voting rights that are referred to in the Constitution. People say there's no right to vote in the Constitution. I always want to say, well, I mean, actually, let's look at the 15th Amendment, the 19th Amendment. Let's look at Article 1, Section 2, which says the people choose Congress, right? I mean, there are rights to vote that are there, but there's no general voting rights provision of the Constitution. And I think for for some folks in our legal system, that it's an important principle that the states get to decide. I think in Bush v. Gore, when the per curiam opinion and when Chief Justice Rehnquist noted that the state doesn't have to let you vote for who for president, that the state legislature could just select electors as the constitutional text does permit. That I thought that was really interesting because, of course, we all know this, right? This is something that is a fact of the way the Constitution is written. But we have had popular elections for president, for presidential electors for a very, very long time. For literally centuries at this point. And if anything is sort of a deeply rooted tradition in America, it's that. And I think that there's a desire to kind of wave in our face, no, that may be how things are, but that's not what the Constitution requires, and the Constitution would permit retrogression in that regard. I think you see some of the same thing in some of the dynamics that Ellen was talking about the various voting rights cases, Wisconsin and then the other states, and actually the case from Texas that came out just last night from the Fifth Circuit in the middle of the night while I was sleeping, which rejected a challenge to a state order from the governor of Texas that said we're going to have drop boxes for absentee ballots, for returning your absentee ballots, but only one per county, which, in Harris County, Texas, which is this enormous county. Houston, which is the biggest part of Harris County, Texas, is the third or fourth biggest city in America. And yet, it's just impossible to think there could only be one of those. And one of the things that the Fifth Circuit majority said in staying the injunction there was, well, look, you didn't used to have drop boxes at all. You didn't have to have drop boxes. And so a lot of these cases are decided based on an analysis of, well, there are lots of ways in which voting is easier now than it was at a time when people are alive can remember. So what are you complaining about? And the positive spin on that, if you want to give an attractive spin to it, it's effectively the argument that I heard Ellen articulating before, which is, well, what's the stopping point to the constitutional argument? How easy do we have to make it to vote, essentially? How many drop boxes do we have? And then it starts to sound very detailed, and we start to wonder why that's a constitutional question. But I think if you're more of a pragmatist about the way constitutional law works, you say, well, this is just the thing that courts do in figuring out what's the boundary of the Constitution. Yes, at some point, I think we can say that it's sufficient. But when you have, and to go back to the Florida example, when you have lots of people who are being disenfranchised, despite actually a state constitutional amendment that sought to enfranchise them, and despite trying to figure out how much money they owe and trying to pay it back, right? And being unable because the state can't tell them how much money they owe, right? At that point, this feels very disenfranchising in a way that I think we can say that's unconstitutional, even if we can't work out all the details of what is required. And, so I was one of the signatories to a brief in the 11th Circuit saying that what was going on in Florida is a poll tax. Mm-hmm. When you're being told, unless you satisfy your financial obligations to the government, you can't vote, that feels a lot like a poll tax. And the money at issue here was a lot greater, actually, than the poll taxes that were at issue in the poll tax cases in the 1960s. And so it really, I think we do have an increasing jurisprudence of skepticism towards voting rights, toward hostility towards voting rights. I think that's accurate.
What did the 11th Circuit specifically address the argument that this is a poll tax?
Yeah, they did, and they said, this is effectively people who have committed crimes and are being required to discharge their financial obligations as a result of their crimes. That's different than a tax that everybody has to pay, essentially.
Mm-hmm. Mm-hmm. Okay, I think we do have a little bit of time to discuss Arizona. So let's just quickly, well, actually, we have a bit of time. We have about 12 minutes to talk about the DNC versus Hobbs case, which was brought under the Voting Rights Act and on which the Supreme Court just granted cert. So, Ellen, maybe you could tell us what the case is about and why it matters.
Sure, and maybe I'll give I'll try to be a little briefer on this one, because I think it actually invites us to think about some of the things Sam just mentioned. You don't have to have a Dropbox. So if you're going to have a Dropbox, how many Dropboxes are you going to have? The Arizona case concerns two rules about bringing in absentee ballots, who can collect, harvest them, limiting that, and then also a specific rule about people who show up at the wrong polling place. And Arizona's practice, or new practice, was if you show up at the wrong polling place, you cast a provisional ballot. It turns out you are in the wrong polling place, perhaps because the polling place has been moved very recently and you weren't aware of it. Perhaps you have moved recently and were not aware that you were in a new place. You made a mistake. Your ballot's thrown out, even though that ballot is casting a lawful vote for, say, any of the statewide offices, that the ballot might have been the wrong ballot for the local jurisdiction, this city ward that you're in. It has these other races on it for which the vote was clearly legitimate. One can debate whether the other ones, but clearly legitimate. And Arizona's practice is to scrap the whole thing. It's challenged under the Voting Rights Act, under Section 2. Standard practice or procedure that results in a denial or abridgment of the right to vote on the basis of race. And the plaintiffs presented a lot of evidence about the way these rules had disparate impacts on particular communities, Native communities, Latino voters, and others. District Court actually rejected all the claims, went up to the Ninth Circuit en banc, fines for the plaintiffs, finding a violation of Section 2, and finding evidence of intentional discrimination, which Section 2 doesn't actually require, on the part of Arizona, looking at the records about how these provisions, Sam's word of retrogression, I mean, in fact, these are rules these rules are making it harder for people to vote, which is not part of the Section 2 calculus exactly, although it is an element of the totality of circumstances to think about it. Supreme Court didn't take this case to affirm. That would be my judgment on, that's not why they took it. It is a big Section 2 case. There hasn't been one. They haven't taken a lot of Section 2 cases on the merits. Section 2 is what was left standing after Shelby County. And in Shelby County, where the court struck down the regional provisions of the Voting Rights Act that applied to particular jurisdictions, kind of freezing in place their electoral rules and requiring them to make showings of non-discrimination before changing them. That gets lifted, and in the course of doing that, the court was very to Section 2. You can challenge discriminatory practices through this sort of more conventional regulatory framework. So who knows? I think they're going to reverse. They're going to say and there are a lot of ways to structure an electoral process, and Arizona's choices are within the permissible and don't violate Section 2. There's been some speculation that the court could go further and say Section 2 is beyond Congress's power under the 14th and 15th Amendments to enact. It's an application of Section 2 to what we might call vote denial issues. It's not a districting dispute. It's about procedures, about the casting of ballots and how that goes. Court hasn't ruled on Section 2's application in this context. Mm-hmm. So it's not an election-related dispute in the way these other ones are. I think it's going to be a big case in terms of its consequences for how the Voting Rights Act is going to be applied in coming years. Mm-hmm.
And Sam, any reading of the tea leaves and how you think the court might decide the case, and more specificity about some of the implications of a decision that begins to gut or does gut large parts of Section 2?
Well, I mean, I agree with Ellen that this is likely to be a case that is going to end in upholding what Arizona is doing. Otherwise they wouldn't have granted cert in this case. I think that that's pretty clear. And I don't think the court's going to use this case to say Section 2 of the Voting Rights Act is unconstitutional. I think it'll be very interesting, though, to see what this court, which is, in all likelihood, going to be a 6-3 conservative court, is going to do with the Voting Rights Act. And I think, they'll give us a lot of hints. There might well be language in the opinions about how this presses the constitutional boundary. There might be language there might be concurring opinions encouraging someone to bring a constitutional challenge to Section 2 of the Voting Rights Act. Back in the 90s, it looked like the court might be poised to strike down Section 2 of the Voting Rights Act as unconstitutional, and then they pulled back from that. But now who knows? And I think the other thing, to note about this case is the limitations on third-party collection of ballots in Arizona were struck down by the Ninth Circuit, not just because they had a discriminatory effect, but also because they were understood by the court to be intentionally discriminatory, that they were targeted at and responsive to voter empowerment drives by communities in the Latino and American Indian communities in Arizona. And the Supreme Court in recent years has done this sort of two-step around discrimination. First, they've said the only way you can show discrimination is by showing intentional discrimination. So discriminatory effect just doesn't really count. And, occasionally we get a case that reads a statute to give discriminatory effect, like in the Fair Housing Act a few years ago. We ain't going to see that again. But mostly they say, look, you need to have discriminatory intent. And then when evidence of discriminatory intent comes in front of them, they have all sorts of reasons for saying, yeah, this evidence isn't good enough. So for example, when, in Trump versus Hawaii, all of Donald Trump's Islamophobic statements, the court said, yeah, none of that matters to our decision. Sure, these are horrible, wretched statements. We disavow them. We uphold his decision nonetheless. Last term in the census case, the Supreme Court said, well, there was violation of the Administrative Procedure Act, but only one justice, Justice Sotomayor, said, yeah, and by the way, there's all this evidence of intentional discrimination. The other justices actually explicitly rejected the claim that there was intentional discrimination. I suspect we're going to continue to see a narrowing of the circumstances in which the court will find intentional discrimination. They probably won't find it here. So I think Ellen's right about the outcome of this case, that Arizona's practice is going to be upheld, and we'll get some tea leaves for the future. But we're probably not going to get the big decision that, the Shelby County of Section 2. That's not happening this year.
Okay, well, I see our time is basically up. I want to thank the two of you for this extraordinarily illuminating conversation. I would have liked for it to be a little bit brighter in tone and content, but you deal with the law you're given. So thank you so much. I will clap on behalf of everyone because they are not available to clap on their own behalf. And just remind those of you in the audience that the next session is on November 10th. With Professors Prescott, Primus, and Schlanger talking about criminal justice reform. Thank you so much for sharing your evening with us, and I hope to see you at the next event. And thanks to the two of you.
Thank you.
Thanks.